Welcome to today's webinar, Divorce and You Civil, where we discuss the dissolution of a marriage under civil law. This webinar is part of Law Awareness Weeks at CDC 2022. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, and the Singapore Corporate Counsel Association Pro Bono Chapter, supported by the People's Association. My name is Liyen, and I'll be your host for this webinar. Before we begin, some housekeeping matters. The first is about Q&A. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar, and you can also vote for the questions by others that you would like answered. If you have a smartphone or a tablet with you, just launch your internet browser, enter www.pigeonhole.at into the address bar, and then key in our event passcode, Law CDC 11, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you are viewing this webinar on a desktop or laptop, you should receive an invitation to launch Pigeonhole. Next, a link will be shared in the chat function to access the handouts for today's webinar. The link will also be provided in the follow-up email sent to you tomorrow. The last point is to please note that today's webinar is not intended to constitute legal advice. If you require specific legal advice, please consult a lawyer. With that, allow me to introduce our distinguished panelists for today's webinar, Mr. Yap Teong Liang and Ms. Abigail Lee. Our legal expert today is Mr. Yap Teong Liang, founder and director of TL Yap Law Chambers, LLC. Teong Liang has practiced law for over 30 years and is a highly accredited family law practitioner. Teong Liang is also appointed by the Chief Justice as a member of the Family Justice Rules Committee, and he also sits on the panel of child representatives at the Family Justice Courts. Teong Liang, I believe your firm celebrates its 20th anniversary this year?
Yes, indeed, Liyen. Thank you.
Congratulations. Okay, tell us a little bit about the work you do as a family lawyer.
Yes, certainly as family lawyers, we do not just the legal advice to the clients to explain what the law is. There's several other components, which I would call the non-legal aspects, which will be to be able to emphasize with the clients to understand their problems. They come to us in a state more often than not of high emotions. Tensions are difficult in the home environment. And I think we need to take a step back as family lawyers to help them assess where they are, not necessarily advise to run to court, get all the legal remedies done, because sometimes that's not the best way to try and help the client solve the problem which they're facing in the home environment.
Yeah, very true. Wow, not so much of it is like sounding not legal. It's the perfect time to introduce Abigail. Abigail is founder and executive director of Healing Heart Center. She has over 15 years of experience as a professional counselor and play therapist, with a focus on working with children and families. She is appointed by the Family Justice Courts as a parenting coordinator and by the Singapore Mediation Center as a collaborative family practice counselor to work with families undergoing separation and divorce. So Abigail, your work focuses on children. Tell us how you came to specialize in that.
Interestingly, Liyen, I started off working with adults first, actually. And what I would find, long story short, is that I would see a lot of the children waiting for their parents after I finished seeing them. And, they would sit down on those benches and then the little ones would then move their feet. And I realized I come to kind of turn them as almost like the forgotten ones. And I realized over time that while we are attending to the parents, many times no one was reaching out to the children. So I started working with them. And during the course of that, I realized that many times, even though they may have verbalization limitation because of their age, it doesn't mean that they don't have needs and they're not experiencing whatever that's going on in the families. So that's why I kind of also took a little turn and I kind of specialized in play therapy. So through the use of play and expressive arts, just giving opportunities for children to be able to express themselves.
Thank you both for joining us today. Yeah. Okay, I'll do an overview before we begin. Some of you may be aware that Pro Bono SG has been giving law awareness talks for a few years now. We conducted divorce-related talks online during COVID in 2020 and 2021. You can find recordings of these talks on our YouTube channel, and the link is provided in the chat function. Today, we will try to cover the topics in the following order. Naturally, we'll start by talking about eligibility to apply for divorce in Singapore. Then we'll talk about ground for divorce, ancillary matters, followed by court procedure and new developments. And we hope to make time to answer all your questions. So please feel free to use Pigeonhole Live and put your questions up for our panelists. Okay, let's dive in and begin with eligibility. The question is, can you commence proceedings in the Singapore court? To answer that, you need to know if you are eligible or qualified to file for divorce in Singapore. So Teong Liang, what are the criteria that must be met before one can file a divorce application in the family courts?
I think the first thing is you have to be married for a minimum period of 3 years. So it's what we call a time bar. So if you are married for less than 3 years, you will not be able to commence divorce proceedings unless you show there are exceptional circumstances, exceptional hardship. So barring that, you basically cannot start any divorce proceedings. So that's one aspect. The second aspect is the question of jurisdiction of the courts. So if you are domiciled in Singapore, you're a Singapore citizen, then you can have the jurisdiction within the Singapore courts to commence divorce proceedings, which means that the family courts in Singapore will be able to hear your case. Now, the fact that you are married in Singapore doesn't give the court jurisdiction. So the place of marriage isn't the criteria.
Oh, so it doesn't mean that if my ROM is here, then I can definitely apply for
No, it doesn't mean that.
Okay.
So there's another group when you can have situations where you have cross-border marriages. So foreigners who come to Singapore for work, they establish themselves in Singapore. In order for the Singapore courts to have jurisdiction, what they will have to do is satisfy a criteria for habitual residence, because they're not Singapore citizens, they're not domiciled. So they have to be habitually resident in Singapore for a period minimally of 3 years prior to the commencement of their divorce.
Okay. So in the case of couples where one is and one isn't, or say one is PR and one might be a foreign spouse, marriage registered here, what in particular, they should they be considering? As long as one spouse is domiciled?
Yes. So domicile obviously is essentially established roots in Singapore. But you haven't, they still are citizens of a foreign country, then you're looking at the criteria of habitual residence of 3 years.
Okay. So when now we've established, right, you have been married for over 3 years, you are domiciled in Singapore, let's move on to ground of divorce. The next step is, do you satisfy the ground for divorce? So if you intend to file the divorce application, you must show the court that you are relying on one of 5 facts to prove that your marriage has irretrievably broken down. Am I right, Teong Liang?
Correct, Liyen. One talks about 5 facts, which you mentioned. Legally, there's only one ground for divorce in Singapore, and that's the irretrievable breakdown of the marriage. Question now is, how do you show the irretrievable breakdown of the marriage? And that's where you come to the 5 facts we're talking about. So the 5 facts being essentially adultery, unreasonable behavior, desertion of at least 2 years, which is really abandonment of the family, where one spouse basically completely disappears right from the face of the earth. Or what will be common will be separation of 3 years with the consent of the other spouse, or failing the consent, which will be in writing, a separation period of 4 years without the consent of the other spouse.
Okay. Does it make any difference which fact is used in the divorce application?
No. Essentially, the law in Singapore is a no-fault divorce. What that means actually is that the reason for the divorce will generally have no impact on the ancillary matters, which means issues relating to maintenance, division of assets, or children's issues. Sometimes where it's fault-based, it is only in relation to, for example, adultery, which is fault-based, obviously alleging, right, the other spouse has committed adultery, or unreasonable behavior where the behavior of the other spouse is unreasonable, which has caused the breakdown. So in that context, it is fault-based, but it's not a fault-based in relation to any connection to the ancillary.
Okay, I have heard on many occasions people who don't believe that.
Yes.
Parties are very often still convinced that, and I suppose, Abigail, you would agree, they are emotionally upset, especially if it is, let's assume that it's a fault that is obvious, unreasonable behavior or adultery. There's a sense of injustice if it doesn't seem to reflect into ancillary matters, right? So what's your take on that, Teong Liang?
There will be some occasions where the unreasonable behavior may have an impact. For example, children's issues. So you may have a situation where allegation is family violence against the children. So that may have an impact on access issues or even care and control issues. Sometimes part of the allegation is maybe a spouse has withdrawn monies from joint account. So it does impact the division of assets. If, for example, you say they withdrawn 100,000, 200,000, then the accountability for that amount that's been withdrawn from the joint account, for example, becomes relevant. So more often than not, the reasons for the divorce are not contested in the courts. The rationale for that is the issue the judge has to decide is who's to blame for the breakdown of the marriage. And really, there's no incentive, or I call it, it's probably not prudent, right, to spend effort and time and cost just to establish who's at fault. So the cases that come to court, most of them are actually uncontested, which means parties eventually come to an agreement for the reason for the divorce and really then focus on the ancillary matters, the financials or the children's arrangements.
That's sensible, because Abigail, if you think about it, would you agree that in any event when a marriage breaks down, it's never so straightforward?
Yeah. I think it's a myth that when people think like it's broken down and then you just kind of see it as you got married and then something happened and then it sounds almost like a straight. But I think there are a lot of like waves and curves that happen along. Yeah.
Very true. Okay, so it's good to know that it apart from situations that directly affect the ancillary matter, as were the examples given earlier, it actually doesn't matter. So let's move on to one's emotional state. Because ultimately, as you had mentioned in your introduction, Teong Liang, when clients come to see you, we think of family law as the practice of the law. We are thinking about how to get the divorce and then the ancillary matters. But very often the first thing that you deal with is the client's emotional state. So I reckon from the time someone begins contemplating divorce, the whole journey to the end of the matter, it is a rather complicated emotional state. Would you say, Abigail?
Yeah, I tend to, again, I think people think of it as like straight line. I don't think it's medium because even from the time where people start contemplating, to during and also post, there are so many different elements, there are so many different considerations, and there are so many different additional steps on different. So I almost kind of feel like you have like a ball of emotions happening over however long this whole process is going to take.
So as a counselor to divorcing couples, are there different types of counseling that for different kinds of situations? I don't know, in the course of your work.
I think I view counseling almost as like an overarching umbrella. So where we look at processing the issues. So I think in terms of counseling, there are different issues and different situations that we can look at. So when we talk about like divorcing couples, I think there is that initial stage of just contemplation. Some might be just a stage of having a thought about thinking through. So in counseling, then we look at helping you to make sense and to help process through how do you come to have such a decision. So and different ones will be at different phases of it. Some might already decide that they want to kind of step up. Some might decide that they want to try and see how to make things work before reaching that divorce stage. And then there are some who might just be sitting on the fence. So we cover that, we work through them, work through the process with them on that. And then you have the jury when decided that you want to separate or divorce, and the emotional turmoil, mental state, changes, adjustment, transitions that have to be made, as well as post. So I think it's not just like, okay, divorce, final judgment, done, we go our separate ways. I think there's still a lot of post divorce situations and emotional state, and also new changes. And I think especially for those with children, having to navigate the developmental milestones, the age of children. So it doesn't just end as just so I think in counseling, different phases, different kind of situations,
I have a question about the time it takes for someone going through counseling. I have had friends who have said they go for a first session and then they feel like nothing much is happening. It's like, oh, how many more sessions am I going to need? So yeah, maybe it would be useful to participants to have an idea of what the process is like. You know, what is it like the first session? What's the counselor looking for? How you can better prepare for it? And then,
I think in this context of counseling, we are also talking about voluntarily kind of going for counseling. I think it's a myth, like there are many myths surrounding counseling. I think one of the myths is that, okay, only go for counseling when things are really bad. Like desperate, please help us stay in the marriage. So I think that's a myth. So I think at any point of the stage that I talked about just now, contemplation during or post, counseling can be very helpful for individuals and for couples to consider. So, some people might be thinking, I'm thinking of going for counseling, my spouse is not willing, but counseling is still working, yes, because you can work on the impact that it has on you as an individual. And then we work on when the other spouse is willing, we also work on the couple relational aspect of that. So generally what happens in like the first few sessions, it's generally about having an understanding of the situation. How did you get to where you are, and what brought you to see the counselor? Because understanding and recognizing that you're meeting a stranger for the first time, the counselor is not your friend, the counselor doesn't know what has happened. So the first session generally is about that, and then streamlining into what are some of the more considered issues that we want to work on, which would then follow a series of review sessions. And I say it depends because depending on which phase and which process you are at, sometimes some people only have like a one-off session as well. Like just with that one session and then thinking through and then having insight like, oh, okay, this is how I got to where I am, and okay, that's sufficient. And then some might have a more extended sessions. So it really depends on the situation.
okay, that's interesting. Teong Liang, you mentioned that that's one of the first things that you have to deal with your clients when they come in, right? So how does a lawyer deal with the counseling part? I mean, what do you counsel? I assume it's a bit different. How do you help the clients? And at which point do you say maybe you should see a counselor?
Yes, we are family lawyers. We are legally trained. We're not counseling trained. But we don't profess to be able to give them that kind of advice. But I think the last probably 5 to 10 years, there's a lot of cross-training for lawyers, for family lawyers, because we find that this is also an important part. The social science aspect is fairly important for us to understand the client, understand their needs, understand the problems. So with that background, not an expert's background like Abigail, right? It enables us at least to have some form of little bit of assessment. We're not diagnosing people, right? So you're not there to diagnose to find whether they have a mental health issue. But heard of different kinds of narcissistic personality disorders and various types, right? So we're not there to judge, but maybe when we come to trying to deal with them, why they insist on certain things. For example, you may have a spouse that say, I don't want the other parent to see the children. So with a bit of understanding of the background of the mental health component, right, it enables us to sort of navigate the climate and what I would call the reality check. So it's not about saying, no, you're wrong to do this, you're right. It's more, how do you think that would impact a child if you want to take this course? So sometimes that self-reflection helps us to help the client. So lawyers are there to always say, this is it, this is the position you're taking. But generally, I find myself in practice and we do, right? We shift away from that. A lot of it is trying to reframe the problem, reframe the issues in a sort of gentler way, so that the client can think it through. It's not about when we meet the client, so that when they leave the office, when they go home, hopefully it still sticks with them, right? And helps them think through these issues. So it's about framing it because they won't see it from that.
Yeah.
To them, it's more often than not binary. You know, it's yes or no, you know, it's me or you. So it's really refocusing, and central focus will be the kids. And that's the common denominator. So whilst they may have that differences, it's just helping them to see that actually they may be common and not to bring the differences down to the level of the children.
Very interesting. Okay, Abigail, I'm just curious, right? Are there some actual tools that might be useful for someone who say maybe facing marital issues? For participants listening in, you know, something that they can actually kind of try to practice and use at home.
I think practically, the emotional aspect, like I said just now, like any individual going through a process like this, it's a ball of emotions. So some form of self-care regime where you are able to have time out where you're not just fixated on the process that is taking place. I think many times, realistically, any individual who's going through the process, it's not like the rest of the world stops. You know, you still have to work, you still have to do caregiving, whatever that entails. So it's not like you can put aside any other responsibility. So I think given the additional weight and the emotional the weight that comes upon a person mentally and emotionally, some form of self-care is good, where you can just take a breather, put a pause on and do some kind of a check in terms of okay, how am I actually really feeling, and find ways to actually be able to use that and help get through it. Okay? And I think social support are really important. Social support in terms of having a network of friends or peers where you can just go to and share. And of course, there is that inclination where you rant to your friends and they're all going to be on your side. So I would also say emotionally, in terms of having a neutral party who's just able to help you kind of sort through, unpack the emotions a little bit, and at times maybe really ask you the questions of, is this really what you want? Is what you are thinking of doing really what's best for you and what's best for children involved. And I also want to add, like, I think practical aspect is also important. Because if you're contemplating divorce and all that, I think things like budgeting, there could be changes in your financial situation. Expenses might look very different. Having a consideration about how that's going to look. And as I have worked with couples and families as well, this is a really practical thing. Just having a calendar, because sometimes there are so many changes that are taking place. There are new arrangements, caregiving arrangements, appointments that has to be upheld. So sometimes practically, even just having a calendar where you can schedule all these things, including time where it's like time off. Because you notice that in your calendar, from morning all the way till night, it's packed with like caregiving or divorce proceedings and all that. You need to have allocated time that is just time off for yourself. And for some people, it might be helpful to actually remember that as a reminder.
I completely agree because
I think sometimes there's also guilt. I mean, especially in a typical kind of marriage, we're not talking about where everything is like broken down. It's so bad, and
People forgotten about the kids.
Yeah.
I definitely have encountered people who don't take time out for themselves because they feel guilty.
Yeah.
They feel bad
Yeah.
towards their children.
Mm,
So
mm.
all the energy is then focused on like spoiling. Okay, lah, not spoiling, but spending time, giving
Yeah.
whatever they
Yeah.
can to the child,
Yeah.
because in their mind, they feel that they
Mm.
have done the child a disservice, right?
Mm.
So yeah, I think that's a terrific idea to calendar some me time in.
It's the age-old analogy. Okay, now COVID, we can kind of like it's COVID a little bit, we can kind of travel. So that age-old analogy of put on your own oxygen mask first before you attend to somebody else.
yes, that's terrific. Yeah, super analogy, very true. So remember to
Table some time for yourself. Yeah. Okay, this is a good point for us to move on to ancillary matters. So in this segment, just for the benefit of everyone, we will be dealing with care and control as well as custody of children. We will talk about maintenance for either the spouse or children or both. We will deal with division of matrimonial assets, where if you have questions regarding CPF, HDB, yeah, please feel free to raise them. Okay, before I move into ancillary matters, let me have a look at some of the questions that you all have posted. Okay, this one is for Abigail. It says, do you usually counsel both parties, or there's a separate counselor for each spouse?
It really depends on the situation. Many times when, again, looking at the situation, sometimes one individual comes first, one spouse comes first, and we work with that individual. And when the other spouse is ready, sometimes we kind of have joint sessions together with them. There could be situations, for example, if there has been a previous history of violence, physical abuse, or where even there is a sense on one spouse perspective where they don't feel safe having joint session, then at times we will kind of separate them first, have individual sessions, and then at some point then have joint sessions. Okay, so there are many different combinations and interpretations surrounding. I have also known counselors where they have each spouse has their own individual counselors, and then when there's a joint session between the two counselors, they then kind of decide who's the one to kind of facilitate the joint session. So many different possibilities. Okay.
yeah, I hope that answers your question.
Teong Liang, someone wants to know, can a person get a divorce without the consent of his or her spouse, particularly where there are no children, but one's spouse spitefully refuses to give consent for divorce?
I think the answer is yes, but unfortunately, that kind of scenario, you're probably looking headed towards a contested divorce. So, for example, the one you just gave, it could be a scenario whereby one spouse wishes to divorce, the other spouse refuses. So the other spouse refuses, so you can't get consensus as to the reason for the divorce. So what will happen is the spouse who wants to initiate the divorce may still proceed to do so, set out his reasons or her reasons why they want to divorce. The other spouse is refusing it, will then defend those allegations, but maintain that the marriage is not broken up. So then it becomes a situation of having to prove his or her case in court. So it becomes a contested divorce trial. To be fair, not many of these cases go to court. As I mentioned earlier, right? They don't want to spend an inordinate amount of money or time, really, for the court to decide, oh, it's your fault. You can't prove your case, so I'll dismiss your application for divorce, which means you still remain legally married after the entire journey. So what some people may do is they end up being separated.
Okay.
Wait for the 3 years, try and get the consent. If there's still no consent, then you wait the 4-year separation period, where you can then file on the premise of 4-year separation. You just have to make sure that in that period of separation, there's no living together as husband and wife, there's an intention to put an end to the marriage at the time of separation.
Okay, so realistically speaking, I mean, I just sort of take it a step further. So when we say separation, say they are staying in the same HDB flat, what would constitute separation for the purpose of divorce?
The law enables separation where parties are staying under the same roof, but they would have to live in separate bedrooms. That's the first fact that the courts will look at. Then during that period of separation, because they're still in the same household, they'll have to demonstrate that they do not have, well, without sounding like MCP, right? You know, the wife doesn't go to the market, gets the groceries, cooks it's her favorite soup, you know, look after her in the same block or anniversary dinner, birthdays, don't visit the in-laws on Chinese New Year. So it's basically a clear-cut separation of household in that sense within a household, I can put it that way, and a separate living of lives. That's why the wording in the statute is live separate and live. So there are some cases where they're staying at the same house, separate bedrooms, but they still go for holidays.
Yes.
That kind of scenario may arise, especially when you have children. So the question asked earlier, no assets, no children, it's simpler. It's just the two adults, right? But when you have children, the courts do appreciate that the parents may still do the holidays for the sake of the children, right? So that's still permissible.
Okay.
But when you go for holidays, obviously, like more likely than not to stay in separate bedrooms.
Yes.
As opposed in the same hotel room. You know,
Yeah.
yeah.
But this thing about the separate bedrooms, right? So say you have been living separately 4 years. Somewhere during the 4 years, maybe for whatever reason, they might have consummated or, you know, been together or slept in the same bedroom, say twice. Does that make a difference if that becomes a defense that one spouse raises?
It's not the number of times, it's actually the period. So the law allows, even during the period of separation, if they do try to reconcile, try and work out the marriage, the law allows that, and correctly so. But if the period is less than 6 months, then it won't be counted against the time frame of 4 years.
I see. Okay.
So if you get together and you end up getting together for a year, and then you say, look, it doesn't work out, unfortunately, and you say, no, it starts 4 years ago, the other spouse may say, no, hang on a second. We did try to reconcile, it was more than a period of 6 months. So would it colloquially you have to valid start the time?
Yeah, so
Right?
we do the
Yeah.
4 year law again.
Sort of restart the time frame. Yeah.
One spouse is going to say unreasonable
Yeah,
behavior.
there's
Okay. Okay, let me see if there's another question that we can ask that isn't about ancillary matters. We do have some questions about ancillary matters. Okay, I guess this might be a good point to deal with this one more question before we move on to ancillary matters. Somebody asked, prenuptial contracts are not enforceable in Singapore, but do the courts consider such contracts persuasive evidence when deciding on, split of assets and child custody after divorce? So this idea about prenuptial contracts.
Yes, it is absolutely correct. Any prenuptial agreement is not binding on the Singapore court. That's the law as it now stands. But the court under the law will take into account the existence of the prenuptial agreement when it considers the division of assets. The reason for that is it gives the court an idea or a feel of what are the intentions of the parties at the time of the prenuptial. Prenuptial is also a complicated, it's not as straightforward as just I have an agreement prenuptial and then look at it, because certain terms would have been set out in the prenuptial agreement. Primarily the prenuptial agreement, you would see as part of the agreement a list of assets that the parties agree will not be divided. But if you then have a 10, 15, 20, 25-year marriage, and it comes to the point of divorce, and you're looking at a prenuptial done 20 years ago, the circumstances are very different. And that's one of the reasons why cannot bind the court. That's one. The second thing is some of the assets that may have existed at the time of the prenup may have been transformed or dealt with in a different way, different from what was originally intended in the prenup.
Right.
So the courts have ultimate ability, right, oversight how they look at all the assets at the time of the divorce. So that's why the prenup, whilst relevant, right, doesn't bind the court, but that's something people need to know.
Okay, I hope that answers your question. Okay, let's move on to ancillary matters, and then we can deal with all your questions relating to ancillary matters. So, as I've said, we will cover child arrangements, maintenance and division of matrimonial assets. So maybe you can just run us through what an ancillary matter, okay, we know what ancillary matters are. What's an ancillary matters case conference, and do parties need to kind of prepare for it?
Okay, the ancillary matters case conference is part of the case management system run by the family justice courts. It's an important part of the entire process. The reason for that is the courts make sure that the cases don't go to state, is moving at a reasonable pace. There are no undue delays because it is not ideal, non-conducive for a divorce case or ancillary matters to be stuck in the courts, right?
Yes.
For a long time. There's no closure of the parties, and they end up getting sucked into, right, and what may become very unhappy. So the case conferences are essentially updates given to a case conference judge, and directions are given for the future conduct or further conduct of the case. Okay. And it's generally done in about 6 weeks, 8 weeks, sometimes earlier, depending on at what stage the proceedings are. The lawyers will attend the case conferences. So if you are legally represented, the party doesn't have to attend. It's the lawyers. But if you are a litigant in person, self-represented, then you would be required to attend the case conference. So in a sense, yes, you have to prepare for it. Yes, the lawyers have to prepare for it.
Okay, so for the benefit, although I reckon quite rare, litigants in person, right? Very briefly, what do they need to prepare?
What they have to prepare is to know the status of the case at that point in time. They need to be prepared in the sense that whether the previous directions have been complied with. Right? If it is, then they need to be prepared as to what's the next stage of the case. So it could be a reply affidavit, for example.
Okay.
Right? Or if there's a discovery, to give some of the documents, answer some of the requests.
Say, for example, about your assets, because it relates to the matrimonial asset division and
Absolutely.
stuff.
Absolutely.
Okay, interesting. Okay, let's move on and deal specifically with the children, because I think there's quite a lot there. What is the court's approach when it comes to children?
The overarching approach is they will consider at all times in every case, but it will be the best interest of the children. So it's not just about what either parent wants, but it's balanced against what they want is then in the best interest of the children moving forward to the future post divorce. So that's the starting point. And in that regard, obviously, that's why I mentioned earlier, there's a reality check. Right? So we do that reality check in the comfort of our office, right? With the client, test whether these arrangements or what you want to present to court is going to be reasonable. If so, why is it the best? Because you would have to justify that to a judge, ultimately.
Okay, makes sense. So maybe walk us through what custody, care and control and access means, and how someone who is thinking about these issues ought to approach the three.
That's a very good question because terminology is important. Not unexpectedly, some people get confused. So custody is about the major decisions concerning the children, primarily health, education, religion, primarily. Health, not so much in the day-to-day talk, but major health issues. Education, obviously, in the Singapore context, primary 1 registration. right? Where to go, which school, alumni, non-alumni, within 1 kilometer, not within 1 kilometer,
Wow.
you know. So those are major decisions. Chain control is a concept of with which parent will the children eventually live with post-divorce. So it's either with mom or with dad. So that's the concept of sole care control. There are cases in which you have what is called shared care control. So shared care control is not an ideology where you separate the kids. So it doesn't mean you have 2 kids, each parent take one. That's not shared care control, because if I link it back to what's in the best interest of the children, splitting the siblings as an arrangement will not be the best interest of the children. Shared care control is not about splitting time. So it doesn't mean they split the week equally in half and that shared care control and everything will work well. Even if you share the week with the kids, with each parent, it's probably about 3.5 days, 4 days, 3 days, 4 days, 3 days, essentially in a week. You still have to have a very high level of co-parenting between the parents. Why? For example, if they're in school, then you've got spending desks, you've got tuition, you've got in the school, who's going to do the homework, who's going to prepare the test, who's going to prepare. A lot of things are going to pick up, things like that. So you need to think that through for shared care and control to work in the interest of the kids. The parents have to have a high level of cooperation so that the kids don't get stuck.
Yes.
The other aspect about, for example, shared care and control is the children will be in 2 different regimes. So you might have one parent that says you need to be there by 8. And the other parent, it's okay, you can be on your gadgets until 12.
Yes.
So in that sense, that co-parenting element becomes important. So it's not in every case you have a shared care control aspect.
Interesting. And what about access?
So if a parent, let's say mom, children lives with mom, she would have sole care control, then dad will have access to the children. And the courts are generally pro access. So access could come at a very fundamental base level, which is encouraged. Reasonable access in which both parents will work out the times and when you pick up, when you drop off, without the intervention of the one. That's the most important thing. Barring that, it could be a situation where the parties may have to agree with it weekend overnight access. Then you got to split the weekends, Friday to Saturday, Saturday to Sunday. Then weekday access nights. If so, how would that impact schedules of the children, particularly their school going, institution, things like that, right? In the Singapore context. Holiday access. So generally, holiday access in Singapore will follow the MOE, which is really the mid-year year end, right? So it's 2 weeks, 3 weeks.
Yes.
The March and September school holidays normally just follow the week. But it's obviously open to parents to say, I still want to split that. And during the mid-year to year end, then we have the ability to travel overseas, provided the travel activities. So these are all examples. It could be alternate public holiday access. It could be important festivals like Chinese New Year, then we're starting to split Eve the first day is the second day. So it can drill down as much as you want.
Yes.
Or it just work with flexibility.
Which is why I imagine
Actually, Abigail, when you counsel spouses through this, I imagine this is one of the very difficult issues to help them through.
Yes, yes.
Right? I mean, if they're in an emotionally heightened state or angry still, how are they going to discuss? Which is why I've heard there is a court case, some Chinese New Year, like it went pretty high up in the courts, and it turned out to be all about access during Chinese New Year or something. So it can happen to parties, right?
Yeah.
How would you advise or you know, what do you think participants ought to consider when they think about these issues?
Yeah. This is my dream market. It's probably sometimes an ideal, you know, they totally disagree, And then they come, three of us, we sit down, we talk about the parenting plan, and then light bulbs go off, and they realize and they remember that one is always going to be the child's father, one is always going to be the child's mother. It's a teamwork effort, we can make it work. That's the idea, light bulbs go off, right? Unfortunately, remember, right, when I talk about the waves and all that come, I think many times when you come in, each parent, and rightfully so at times, would want to hold on to what they believe is best for the child. And I would like to suggest that many times that's just one side of the picture, that the other spouse, no matter how badly you think of him or her, do carry assets and strengths that is contributing to the interests of the child. So in terms of like my role as a parenting coordinator, that's what we see. It's a family support role. I try to help them to address and also resolve disagreements that they might have about co-parenting. And it's really all about making co-parenting work, and it's about teamwork. So sometimes I joke and then I tell them, you know what, you don't have to like each other. Can we just work together as a team for the best interest of your child? So that you are not adding on strain on your children unnecessarily. That's it.
I know that when it comes to children in particular, you know, going by the many permutations that you've offered, right, Teong Liang, it is inevitable that parents will play a part in trying to influence their children. Okay, so two parts to the question, right? Part one is the legal question. You said that the court considers the interest of the child as paramount, most important. How does the court do that? Because behind the scenes, when they go home, you know, obviously the parent's not going to try to prompt the child in front of the judge and all that. So how does that process work? How does the court take into account the best interest of the child when parents are probably involved in maybe persuading a child to maybe live with them instead of the other parent, stuff like that? And then the second question is, how do you help the child, Abigail, you know, because parents will naturally be talking to them. And I imagine children of different ages also respond differently, like a child who is maybe below 10, you know, a minor, and a teenager may respond very differently to parents trying to influence them in such things, right?
The answer to your first question, Ian, will be this. That will actually cater for the highly acrimonious kind of cases, right, where they are quite estranged, right? It could be a toxic environment for influencing the children against the other parent. The courts have the ability to direct welfare reports. So it could be a welfare report from within family justice units, the CAPS counselors, in which you have a family court counselor who will interview the children, interview the parties, get into the background and see what's happening and try to, and they will prepare a report in which it's recommended to the judge within that report what would be the best solutions for the children. So that's one aspect. The second aspect is judicial interview. So judges have the ability to interview the children. So different judges have different preferences, but that's an option that's open. Another way is appointment of child representatives who will be able to interview the children. They want the role of a child rep who can actually visit the house. We will, as child reps, will also care for the court with the. So all this sometimes is viewed from a different perspective, the child's voice, as they call it. So we may have some parents saying, yeah, the child doesn't really wish to see it, or the child prefers to live, right? Which is why I said earlier that whilst we are not psychologists and psychiatrists, right, counselors, we have done, speaking for myself, I've done reports in which I've worked with a family court counselor to come up with a report for the court. So that was very enlightening for me in the first place to see the real firsthand, right, how the counsel deals with children. So those are things that assist the court because that would be independent view, as opposed to positional view like the parent.
How often does that happen? I mean, in every situation where maybe parties cannot agree as to the children, the court will interview the child.
No, not necessarily. So they have what I call an argument tools, and in recent times the courts have piloted multidisciplinary approach. So they would either appoint a case companion counselor, or external mental health professional to assist the parties whilst the case is ongoing in the court. Yeah, to try and work out arrangement, what the best solutions for the children.
Okay, interesting. Okay, Abigail.
My second question. Yeah,
I think from
the
as
child's
the-
perspective.
Yeah, from the child's perspective, I think one, from the perspective of a parent, this is where, sometimes I say as a counselor, and ask hard questions. I think the parents do need to ask themselves, if I am going to say something negative, or I'm gonna say something about my ex-spouse, like the parent to my child, I think they have to ask themselves, what is the purpose and intention of sharing this piece of information with the child? And not having the assumption and the expectation that your child is going to interpret and receive the information as how you would as an adult. Because children are really not the real adults, and cognitively they're developing a sense of stage, and they don't necessarily interpret or make meaning of the information as an adult would. So, asking yourself that question, what's the intention, what's the purpose, how will it help the child? If I'm sharing certain kind of information, and do the benefits really outweigh the risk? And I think sometimes I challenge parents and I ask them, if you were still happily married, and given a situation, would this still be the same kind of information that you share with the child? So the whole purpose and the principle here is about minimizing harm to the relationship. And I know it's challenging, it's difficult, it's not linear, but yet when we think about the best interest of the child, that's some of the things to consider. With children, again, different children, depending on the developmental age, they do process information differently. So I do encourage parents to almost have like an open door policy, in the sense where allow the child to be able to come to you with any questions at any point in time. Because, something happens today, it might be 6 months later before the child comes back and say, hey, by the way, I have this question, and you're like, wait, I thought we settled that 6 months ago. Because they are constantly developing, growing, and information that's processed by them differently. So having that.
And I think keeping in mind that the divorce journey
Is long. So from the time the marriage started breaking down or having issues, I think children already have a sense, right? They know, and that emotional journey for them probably begins from there. So it just occurred to me that, when we think about ancillary matters, the communication between parent and child during the entire divorce process can be very long. And so it befalls the parent to constantly remember this question that you've just, posed to them is something they have to keep asking themselves. Because, 1 month you may be, okay, we are quite calm, right? And we can settle certain things, but then something happens and next week you're so angry, you just want to change all the arrangements again. So, that's something to really keep in mind, that the best interest of the child is not something that you think about like a one-off. You have to be constantly thinking about it. And I suppose even after the court order has been issued, because then comes the execution part. And people do go back to court because guess what? The court did order access, but then the other parent refused to comply, right? So it's a long journey.
And I think in the end, just to add, I think it's a myth, I've heard so many parents say, the kids are so young, they're not gonna know, they don't know what's going on. They're not gonna remember. I beg to differ.
Yeah. Yeah. I bet in your experience,
Because it's play therapy, so you also deal with the young ones and you
Yes.
can see the impact it has on the children. How
And
does it sometimes manifest?
many times, if we're talking about the younger ones, because one of the myth again is that they're so young, they're not going to remember. And young children, be like ages 2, 3, 4, they're not going to sit down and like us, and then say, I'm really angry with my father and mother because they've been fighting and arguing. But what they might do is they might come to my office and then they might grab like a dinosaur or a tiger and then fighting each other. And then one small little tiny sheep in the middle, just being caught in the middle and then just kind of looking up at them. And that is very telling of the family atmosphere and kind of what goes on. And we do see, like I do see themes and patterns kind of surface. Yeah. And again, you see that very split kind of expression. I think many times they might think that children, it's another myth that in divorce situation, if the children are affected, it means that they display some very unhealthy, inappropriate behaviors, temper tantrum, meltdowns, nightmares, and all those are signs that I think we see in children. However, there's also a continuum where disobedience to obedience. I've also seen children who overfunction and overperform. Suddenly they become this best kid. They become this best student, as a way to try to keep the family together or to please both parents. So that there is that continuum where it's not just temper tantrum meltdowns. You also have those who become over functioning and over.
the other extreme where they
Think that if they behaved better, they would keep the parents together. Yeah. Okay, that's very interesting to know. Let me just see if we might have a question regarding a lot of it is about division of matrimonial assets. So let's deal with maintenance and division of assets before we deal with the questions regarding ancillary matters. So Teong Liang, tell us, when it comes to maintenance, many households nowadays are dual income. So does that mean that if a spouse is earning income, then he or she cannot apply for maintenance from the other spouse?
So we are now having a discussion on spousal maintenance.
Yes.
So what the courts look at in spousal maintenance will be, one, what is the income of the parties? What are the reasonable expenses of the parties? And when you look at expenses and you look at income, in this case, obviously, wife, it's spousal maintenance being the wife. If she's earning a very good, decent salary, then I think the chances of her getting maintenance on top of the salary would probably be challenging. You may think I counted in the past, oh, if that's the case, then I shouldn't have worked. I always share with clients that those kind of thought processes. So say with a salary, at least you know that your employer is going to pay you. You're going to get CPF from the employer. If it's spousal maintenance, firstly, you may not get the amount that you're earning as salary. And it may be delayed, etc. So whilst you may not get a lot of maintenance, given the factors the court looks at, you may be better off having that regular income ultimately. Right? It's because I think from a psychological, emotional point of view, you're not financially dependent on your ex-spouse, and the economic power imbalance sometimes may work against wife, ex-wife. So yes, dual income, wife earns good, because the cost do take that.
okay. So
Before we move into child maintenance, there is a question about spousal maintenance. Someone wants to know, is there any concept of long-term wife maintenance if she is not working or hasn't worked for a long time?
The liability period for spousal maintenance is until she passes away or she remarries. Okay, so that's the legal liability period. If the wife has not been working, the question of maintenance we dealt with at the time of the division of assets and maintenance and ancillary at the stage. And in order we paid either for monthly maintenance for the wife or a lump sum maintenance, depending on the case.
Oh, there's such a thing as lump sum maintenance.
Yes, for the wife. So spousal maintenance lump sum means it's a one-off payment. There's no more variation in the future. It's a clean cut. So where you have a situation of no marriages but no children, or no marriages, you want a clean break because the kids have already grown up, reaching almost adulthood. They may want a capital sum in order to set them up moving forward as opposed to month to month. So those things are what lump sum maintenance. If it's a monthly maintenance, it's subject to variation in the future, upwards or downwards, depending on whether you want to ensure material change or circumstances.
Okay. So I hope that answers your question.
Basically, it is until she remarries or to death.
Yeah.
Okay.
If I may just look
Yes.
back, the question
It was also, if I heard correctly, if the spouse is not working, right?
Yes, or hasn't worked for a long time.
So it hasn't worked for a long time, obviously affected. And at the point in time when the court has to deal with the issue of spousal maintenance, how long then the wife been out of the job market, or what was the industry issues in previously. So sometimes if you just are unable to get a job, the courts will also want to know what efforts you make. And I think in the Singapore context, there are a lot of different programs where you can retrain yourself, upgrade yourself, upskill yourself. So, but to be fair, some of the wives also have that linkage back to care for the children. You know, so again, depends on what age the children. So if the children are in their teens, obviously you can't run an argument, right? They have to look after them 24/7. As though they're infants or babies. So they are all independent. You have the ability to go out and find at least a part-time job.
Another question about maintenance. Can a husband get maintenance from the wife if the husband is jobless due to a disability and the wife earns more?
Yes, the law changed a few years ago.
To allow husbands to claim maintenance from wives, but in very certain specific instances. And one of that is, as in the question, you are incapacitated, right? Which means arising from your incapacitation. Then you have
Each child. Okay, so each child will differ depending on their age group, etc. So once you are able to sort out
out a monthly breakdown of expenses, then you know what are the core expenses for each child. Then you're looking at who's then going to support the children with those expenses. That goes back to both parents working, one parent only working. If both parents are working, what the courts do and the approach taken will be that they will take the combined income and apportion it. So if the husband and wife earns about equal salary, then they'll share the cost in that regard.
Oh, does it matter what the practice had been in the family? Let's just say a dual income, but when it came to the children, which I think is quite common, right? One spouse maybe the income slightly lower, so whatever he or she earns, he takes care of himself. And then the other spouse that's earning more then takes care of household expenses, including children. So later on when they split, does the court take that into account in determining maintenance?
The answer is yes, but the court's not bound by a previous arrangement within the family. It gives the court an idea. But again, earlier we discussed, right? When a marriage breaks down, your cost of living changes quite drastically because there's no longer economies of scale, so to speak, right? So the expenses are different for the individual spouses.
Oh, okay.
So it's really trying to assess what would be required at the
Time the court has to decide on three matters on the issue of child maintenance. But child maintenance is monthly. It's very seldom computed on a lump sum because it's very hard. So child maintenance is generally monthly and will be subject to change. It doesn't mean that parties have to keep coming back to court. So what we try to do is inbuild an idea of a yearly review between the parents. That's probably what you normally do in the tech family. You know, and then have that discussion. Because some expenses will, after a while, disappear, and there will be additional expenses coming in. It may equalize out at the end of the day, but it's just having that conversation.
Okay. Enforcement. Actually, so in an application for maintenance, I forgot to mention this or ask this. I understand that when it comes to maintenance, it is not necessarily tied to divorce, right? So it's something that you can ask for at any time during the marriage.
That's correct.
So maybe practically speaking, for the benefit of our participants, one needs to be prepared. If let's say, it's tough maintaining my kids or something. Actually, I do know of an actual story like that, where the marriage is sort of broken down, but spouses have continued to stay together for many years for the sake of the children. They were young then, and then, subsequently they grow up. But because they're not really on very good talking terms, and so one spouse, instead of always having to say, oh, actually, so-and-so needs tuition monies now because he's struggling in school, that spouse who is earning an income ends up just footing more and more of the bill, right? So two questions. One is, in a scenario like that, when the divorce finally happens, just because the one spouse has been taking care of the children, because, he or she doesn't want to deal with the discussion with the other spouse, almost to the point that it's been very burdensome for him or her. Can that change? Can she apply or ask for a different proportion during the ancillary matters hearing and say that, look, actually, yes, I've been doing this for years, but it's really difficult and he should or she should really carry a bigger burden. And then the second question is, what documents need to be prepared in a maintenance application?
Yeah. So the short answer to your first question,
Yes, it can be done. So you sort of readjust the proportions at the time of divorce, right? The documents really are documents in support of the expenses for the children. The ideal scenario you just painted would be obviously the other spouse would have the ability, right, to maintain, but chose not to.
Yes.
In that sense, and therefore he should step up his responsibility post breakdown. Not just because of responsibility, but because he actually can afford it.
Yes.
And then that comes into the dual income, that comes into proportion for them, which the parties may not have applied it in the course of the circumstance leading to the breakdown or difficulties in marriage because they may not have known. Right? But when it comes to the ancillary matters, decision to be made, children's maintenance, that will be the applicable program. And so yes, it can be adjusted. So you're not sort of stuck there forever.
And so I suppose in preparation for any maintenance application, standard things like your receipts, your monthly expenses for the children, do you need to keep it over a long period of time? Do you need, say, for example, 12 monthly expenses, tables or charts, or is it like?
I think anything between generally 6 months.
So I think it's good enough because some expenses will go up and down, but the 6 month period will give you a fairly decent average spending. Sometimes they will use credit cards statements because they tag things to the credit card payments as proof of expenses. So there are many different ways how families may spend. Nowadays, if you're all on cashless, right, and you're tapping your phone, then you also got to be aware that your own bank account will have to come out, right? Because previously you've already been paying in cash, but now actually you have documentary support because it actually comes out of a bank statement.
Yes.
You know, so it's how talking about preparing. Then yeah, if you're looking at justification,
better.
it's even better actually.
Yeah.
Yeah, it's even better. Except for wet market.
That's true. Thankfully.
But to be fair, some wet market also has the,
Yeah. Oh, that's
the,
true. Yeah.
the tag.
Yes. Yes. Okay, let's quickly move on to enforcement. Can you walk us through the enforcement procedure when maintenance isn't paid? And the different enforcement orders that a court can make.
Yes. So the starting point for an enforcement of maintenance, you need to have in existence, obviously, a maintenance order, order of court.
Once you have that, and there's a default. So in any court order for maintenance, what you normally see is the amount to be paid. When paid, normally the first day of each calendar month and on subsequent months. You also see in the maintenance order that such payments to be paid into the spouse's designated bank account. So that avoids any dispute as to whether it's been paid or paid or not. So in an enforcement, you're just basically having to identify the period of arrears, for one. Number two, the amount of arrears. And number three, the document in support. The application is to the family justice funds. It can be done through online, or it can be done by going to the family justice fund. It's basically a maintenance summons that's taken out, right, to produce the order of court. To identify the quantum. The courts will then fix a mention. Normally that mention will also entail parties attending that mention and will be sent to a maintenance mediation chambers to try and see if that can be resolved. Because you already have another one. The issue is not too complicated in the sense, because it's did you pay or did you not pay? This is the amount that's the badge. If you did pay, then if you show what you paid, it sort of helps to resolve. If you hadn't paid, then the question is why? And do you have a proposal of making statements? And you can resolve that, then there's no need to get into a hearing, right, for a court to do that. But just to bear in mind that if you're in arrears, you come out with an installment, the existing monthly maintenance moving forward still has to be paid. It's not a substitution, right? So if your monthly maintenance is, let's say, $1,000 and you're in arrears of 2,000, you have been 500 per month over 4 months. Then that month you're going to pay 1,000
For the next 4 months.
for the next 4 months. Correct.
Makes sense.
If not the real snowballs.
Yes, of course. Okay. I realize we have quite a lot of questions about division as well. So let's move on to division of matrimonial assets so that we can have time to talk about mediation, which I'd like to get to. Quickly, Teong Liang, what does the court look at when it divides matrimonial assets? How's the procedure like?
I always like to have this thing called starting points, right? So the starting point is the courts define as a matter of law all assets which are acquired during the marriage. So it can be the joint names of parties, it can be the individual names of the husband. So it's about listing out the assets first. Step two would then be identifying what the values corresponding to these assets. So let's take a house, for example, a matrimonial home. You're going to take the current open market value, net off the outstanding loan. That would be the net value that would be subject to division. Okay. Once you have sort of identified the list and the values, then what you will have is actually the pool of matrimonial assets in terms of its total value. Now, how do we then divide that? The courts will then look at each spouse's direct contribution. What a direct contribution. Direct contribution is essentially who paid what towards the asset acquisition. So if it's a house, it's who paid the down payment, who paid the mortgage. So for CPF contributions, that's considered direct contribution. Renovations are considered direct contributions because it enhances value. Then they also look at the indirect contributions. Now, the indirect contributions has two components. One is the indirect financial, who's been paying for the family's expenses during the marriage. And the other component would be the non-financial contributions. So what is that? That is the role as a husband, role as a wife, or role as mom, role as dad. Right? So it's not monetary, that's why they call it non-financial. So it's a bit more not so tangible by being able to support it by documents, but it's about, there's there sacrifices on the part of the mom, giving up a job, right? So that's the indirect. The courts would then look at the weightage between the direct and the indirect. In the longer marriages, the weightage is more or less equal. So there's no emphasis on either or direct or the indirect. And that's the division essentially. So it is not an automatic 50-50 split of asset on the same level.
Right.
That the statute says it's just an equitable division, but it just equivalent can be a 60-40, depending on the contribution, or it could be a 50.
Right.
But generally speaking, in the long marriages, which long marriages being 20 years in the firm, cases do suggest that the cost do decline towards an equal division. Whereas without the need to pay into all this nitty-gritty, because one can appreciate that if you married over 20 years, right, trying to find all the contributions around, can be a huge challenge because not everyone will have documents. Institutions will not hold documents for such a long time.
Okay, some interesting questions about division of matrimonial assets. Someone asked, what is considered matrimonial assets? We have answered. And then he or she goes on to say, if the spouse did not contribute to any payments of the property, but it was purchased during the marriage, is it still considered matrimonial asset?
Yes.
So I go back to the starting point.
Yes.
The date of purchase, if it's during the marriage, is in the pot. Then what share the spouses get, then look at who contributed. So in this case, probably the direct contribution would be, in that example or in that question, will be 0 for the spouse and 100% for the other spouse.
Right.
Then you're looking at the indirect. And so there will be some adjustment. If you look at it in that kind, under the law, it's called the structured approach. What I've just been mentioning. The spouse will not get 0 because there's an indirect contribution component. And so even how low that indirect, there will be some percentage.
Right. Which then leads nicely into the next question.
Right, which I definitely have heard on several occasions. If a couple co-owns an HDB flat as a matrimonial home, can one of them keep the house after the divorce? Or will HDB force the couple to sell and split the sale proceeds?
The answer to the question depends on type of HDB flat. So you may have bought a HDB flat direct from HDB. Then you are stuck with a minimum occupation period there. So if you get a divorce during that period of the MOP, that means you can't sell, right? Because the MOP doesn't allow you to sell. Okay. Then your other option is either surrender it to the HDB, or between the parties you buy out each other's share. Then whether your spouse is able to buy over the share has many different considerations. One is affordability. 2 is whether or not you actually satisfy the eligibility criteria.
Oh, because you can't own it as a single.
Single you can. I think over 35, then it depends on
Some criteria.
criteria. So what I always suggest to clients is it's best to get to the HDB to try and find out as much as you can.
This one is a bit interesting. What if one marriage partner passed away during divorce proceeding before judgment? Will it affect division of assets if it has been actually pre-agreed already?
So it depends on whether interim judgment
Is it granted or not? Because if interim judgment has been granted, the court will consider it divorce. Right? And the division will still take place in that sense.
Okay.
But the proceedings were made. If there's agreement, then it's a question of whether you follow through with that.
Okay, so if it's after interim judgment, before final judgment, it is still considered divorced. Therefore,
Yes.
the Intestacy Act will not, I mean, it will affect the spouse in that way, right? Because now he or she is
Yeah,
not
because the
wife.
assets will be divided in that sense post the interim judgment.
Okay.
So the law is that without the interim judgment, the court cannot divide assets. They will not have the jurisdiction. They only can divide the matrimonial assets upon the grant of divorce.
That explains why it's a stage 2 process.
That's right.
Oh,
That's right.
I never thought of it. Right? Okay.
Mm.
This one is an interesting question. Divorced wife refuses to move out after court order. Can I collect rental?
Good question.
Okay, so it's after a court order. So the court order on the division would either say that the spouse will have bought over, paid off, right? Then obviously at the point in time of the completion of the transfer, the name would have transferred right from one spouse to the other spouse.
Yes, we have to make that assumption. So
Yeah.
basically the question has some things, unknowns that we have to deal with. Okay.
Correct.
Yeah.
Correct. So if the transfer is all completed and the property now rests in its single spouse and the other spouse is just squatting there, right? Legally, that other spouse has no more legal rights. Okay, because you're now the sole owner. But if the transfer is not been done, right, then it's a question of taking enforcement to get that transfer carried out.
Are assets held in trusts included as part of matrimonial assets? This will be our last question on division.
It depends on the nature of the trust, when that trust was created. So put in a different way, if there are problems in the marriage, there's a lot of money and assets, and suddenly when it comes to division, one spouse declares, sorry, I got all this is out of the pot, right? Because it's now under trust. So we then look at when was the trust created? What's the purpose of the trust?
And the court can go behind that and say that
can.
it still falls into
potentially can.
matrimonial pool.
Yeah.
Okay.
It can.
Okay, good to know. Okay, we tried to answer some of your other questions after we've quickly dealt with the divorce proceedings in the family court. By the way, the Family Justice Courts has an excellent set of updated leaflet and booklet, which we have included as handouts for you today, showing you the divorce process. So please download those resources. They're very useful. Maybe you can just summarize the process quickly for parts, because I think by now they have an idea. We've gone through the grounds. We've talked about ancillary matters. What is the divorce proceeding like in the Family Justice Courts?
I think the
Approach and the ideal would be if the divorce is uncontested. The better ideal is that the reason for the divorce and the ancillary matters are pre-agreed for filing. So when that happens, then when you file it, it's just filed a simplified track. You probably can get from start to end of the entire process probably within 5 months. So that's the idea, to try and get review. So process-wise, parties should have that discussion to try and resolve the before. If you can't, then you have to file then obviously all the documents that hopefully the divorce reason is uncontested. But then you leave the ancillary matters to be resolved. But the children, then obviously you have mediation in 2 years.
And as you've earlier mentioned, right, once the interim judgment is done, divorce is over, then that's when the ancillary matters comes in, and that will be stage 2 of the divorce process.
That's correct.
And Abigail, just quickly for the benefit of some participants, if there are children below 21 years of age, there is a special session called the Mandatory Parenting Program that couples must attend.
That's right.
What does it entail?
It's now an e-learning platform. So basically, the learning platform is like the online register. It includes some self-assessment tools just to help you understand a bit about your current mental situation and understanding the needs of your children. And it just covers, it really broadens your scope of consideration about issues that you may not have considered before. So things like financial challenges of divorce, the impact that divorce would have on living arrangements, and then custody, care, control, access issues, and also the importance of co-parenting and coming up with a parenting plan. And after you finish that e-learning platform, you then have like a 1 hour consultation session with a counselor. And these are counselors from either the divorce support specialist centers or the strengthening family service centers.
Okay, yeah. Okay. And then that's something that
They must do before they can file for divorce. Okay. Let's talk about mediation. That's really a big topic because if you Google divorce statistics in Singapore, it seems to suggest that over 70% of divorce cases are settled at mediation. Is that correct, Teong Liang?
Yes. It goes through the court system where you have mediation, where children under 21, you get to a family dispute resolution
center and discuss children's issues as well as mediation of financials. Another option for mediation is private mediation outside of the court system. So mediation is a very effective tool, has been for many years now, to try and resolve this kind of disputes. Right? And there are certainly benefits to the mediation because both husband and wife, parents, have a stake in the outcome. They reach an agreement. I think one of the other benefits of mediation is they can agree to things that the judge may not have the ability or the jurisdiction to order. So if I take that trust point you mentioned, so in a mediation, you say, okay, I got this pool of assets, right? Children are getting into university. You want to carve out current assets, put it as an education fund. That's it can be done by agreement. But in a division, it goes all the way, they're just dividing the entire pool. The court would not be able to say, I carve out this part to keep aside as an education fund for the kids.
right.
That will be taken care of by way of meetings in the future.
So there's actually more flexibility in mediation.
Absolutely.
Yeah.
Absolutely. And you can be creative about how you want to reach
Mm.
your
Settlement terms. So yeah, I would encourage mediation. I think a lot of family lawyers would encourage mediation. Starting point, right, to try and resolve it.
Abigail, earlier in the introduction, we said you were appointed by the Singapore Mediation Centre as a collaborative family practice counsellor. So when it comes to mediation, what does that role entail? What do you do?
So while in my capacity as a mental health professional, so I'm not a mediator, but there are times within the counseling process where I might need to have some kind of negotiation, mediation skills that take place. But in my role as a collaborative family practice, like mental health professionals, what that happens is you have two individuals where they each have their own lawyers. And then I come in as a mental health professional to be able to offer perspective with regards to the emotional state. It could be of the individuals or where there are children that's involved, offer perspective with regards to that. So it just gives that clarity. And again, it's collaborative. So it's almost like everything is kind of put up front. And we do the best that we can to try to decide as much of the ancillary matters as possible in agreement so that they can then move on to the civil matter.
Okay, that's helpful. Okay, before we try to answer a couple more questions, I'd like to quickly talk about developments in family law. Because in our earlier talk in 2021, we did discuss the concept of therapeutic justice. We talked about developments in the family justice courts. Teong Liang, are there any update of those developments? Is there a new approach to divorce cases going forward?
no, therapeutic justice is gathering steam.
So it's about trying to problem solve for the families, trying to be less inflammatory. And it's a different mindset shift approach of trying to solve disputes between families. I think the development that's probably coming up, earlier we mentioned about the 5 facts for divorce. So now there's going to be a 6th fact. That's called divorce by mutual agreement. It's not in law yet. It's likely to come up by probably mid of 2023.
Okay.
So it just gives an option of spouses who actually agree to have a divorce consensus to actually file under the 6th fact, which is divorce by mutual agreement. However, there are in consideration certain criteria. One of those criteria would be that the agreement must be in writing. Parties will have to confirm that they have made efforts to reconcile the marriage. And they've also considered the arrangements for the children, including financial aspects of that. So it's what we call maybe watch the space, but there's an option to have a non-contested divorce and no fault, without having to wait out 3 years or 4 years separation. So you may have some couples who, there's no adultery, there's no after a while just can't get along for a variety of reasons, and no separation. So under the existing law, they're sort of stuck, right? You can't create unreasonable behavior there because it none exists, and you have to wait out the period, which doesn't make sense, right? So I think the idea of the TMA came about. But obviously they will have to be safeguards so that it's not about just quickly getting a divorce, because I think the institution of marriage is still critically important, right, in society. It's still the fabric of society.
Yes.
Okay. What about Abigail? I mean, you've been with the Family Justice Courts for some time, and now in view of this, as Teong Liang says, therapeutic justice gaining steam, do you find your role increasing, changing in the Family Justice Courts?
I quite like it, in terms of therapeutic justice, because I think many times this emotional mental health aspect seems to be very distorted. Now it seems like we are just being very holistic and we are all working together to support the family. Like what Tong was saying, problem solve, and also with the board. And I think what one of the new developments that's also surfacing is the panel of therapeutic specialists that's coming up. And this basically, just now we talked about how it's not clear. There's so many emotional things that surfaces during the legal proceedings. So this is a service basically where individuals can actually have access to mental health professionals from the private sector, so psychiatrists, psychologists, counselors, anytime during the legal proceedings, and to be able to access those kind of specialist interventions depending on the situations. So it's an added support for these individuals and families.
Oh, that's very good to know. Okay, let's
I think we are close to the end of the webinar, so let's deal with a couple of questions before we close. There was an interesting question here. I hear people backdate their divorce. So is it okay to say when things start getting bad, that's when the timing started? So this, I believe, is for you, Teong Liang.
Yeah, I think things getting bad is very different from backdating.
So backdating is a clear no-no. Okay. When things start getting bad in the marriage, one can term that as that's when the marriage started to break down. It may not be divorce yet, right? Because I think the idea or the discussion of divorce sometimes comes out a bit later. The problems in the marriage, trial separation, and work through it. So when you file a divorce, that's not necessarily the time the marriage breaks down. It could have broken down before that. So yes, one can say that the marriage has broken down slightly earlier for the following reasons. Separation doesn't necessarily mean it happened at that point in time. Because if you're broken down by partners still working through, there's no intention to put an end to the marriage. There's no separate households, no separate lives. So that's quite a different.
in fact very
Would it be right to say that this question brings to mind divorce by mutual agreement? So in a situation like that, the backdating, probably they were trying to overcome the hurdle of the 3-year separation, right? Maybe both parties agree. I mean, from the question, it seems to suggest that. So I suppose now or in future with divorce by mutual agreement, that's something that they wouldn't need the date. They
That's
can
correct.
just agree
Yeah.
to separate
Yes.
divorce.
The only date they will
Need is they have to be married for a minimum period of 3 years.
yes,
That's
all
the
the way
only,
back
yeah,
to
all the way back, yeah,
eligibility,
correct.
right? Okay. One last question.
If the spouse agrees to give the HDB house to the other partner, does he himself have to pay back the CPF used to purchase the house? So how does the CPF element? I think this one is quite technical.
The CPF rules require on the sale of HDB flat or for that matter any property, right, or a transfer, a refund of the CPF plus accrued interest. Okay, that's the starting point from the CPS perspective. But if you're over 55, your minimum sum, you may not need to refund, right? So it depends on when that transfer is to take place. The law does allow transfers to take place without CPF refund. As part of the orders, the court has powers to make the division of assets. But if it's just purely by agreement, what we normally would suggest is you may word it out, send it to the CPF board for its prior approval before finalizing it as a court order. So at least CPF board has the opportunity to confirm whether that's workable for them. Okay.
I think that's all that we have for today. Thank you very much, Abigail and Teong Liang, for joining us and all your insights. We hope you found our discussion this evening useful. At the end of the webinar, a survey form will pop up on your screen for your completion. We appreciate your comments as it would help us with future webinars. If you would like legal advice on any specific legal issue and you are keen to register for a legal clinic session, you may write to us. I think the email will be made available to you when we send the follow-up email tomorrow, because I originally was enquiry@probono.sg. Now I'm not sure if it's the same or it's help@probono.sg. And finally, with that, we would like to thank all of you for joining us today and have a very good week ahead. Thank you, Abigail and Teong Liang.
Thank you. Thank you. Thanks, Abigail.
Thanks.